Well, good afternoon, Stuart.
Hello.
So here we are, another video, 3 days in a row, I think, and coming to you from normally sunny San Diego, not sunny today, a little cloudy.
Yeah, a little cold.
And we're going to talk about some clouds moving over the lively side of this case today with that subpoena.
What is there something that happened with the subpoena?
Yeah, have you been living under a rock?
I guess.
Well, let's start by giving credit where credit's due. So Katie, Without a Crystal Ball, broke the news last night. And producer Eric, if you could show her video.
Yeah, this is Katie's page here. This is the video from yesterday. I saw she also just put one up an hour ago. I started watching that, but here was the big one here. Blake Lively's fake lawsuit to illegally dig. Yeah.
So great work to her just in terms of finding this out, however she did that, and then reporting it. She was the first to report on it, and it was very interesting. Now, Stuart and we did get a call from Josh Boswell with the Daily Mail on Wednesday.
Wednesday morning.
It was Wednesday morning. Called up the office. Eric talked to him, and then we talked to him. And he told us that he had certain information that the deal in talking to him was we were not to disclose anything in exchange for him, telling us what he knew and asking us some questions. So we couldn't disclose anything until his article came out, and we agreed to do that.
And I want to say that takes nothing away from what Katie did. I think she has a staff. She's on her own over there. And for somebody to go and figure this out, we didn't figure it out. We had the Daily Mail reporter call us and explain it to us and walk us through it. But Katie, kudos to you. I've really enjoyed your stuff. You deserve the credit. This is why content creators that are working around this case are so important. And, you think you got to look at CNN or Fox News or MSNBC to get the stories. And Katie was able to break it, figure it out some way, somehow. Maybe she's willing to share how she figured it out. That's what I'm curious about. But kudos to you, and good job reporting it, breaking the news.
So what we have found out, and Katie has reported on this, and now we know it as well from the Daily Mail article, is that Blake Lively, through a company called Van Zandt Incorporated, filed a lawsuit in New York. And we're going to actually link a copy of the complaint in the description below.
It's already linked.
Yep, it's in the description.
Okay, great. And it was filed in the New York, they call it the Supreme Court there. It's always confusing to me because here our first level of courts is superior courts. Supreme Court is like the highest court. In New York, it's reversed. So the Supreme Court is where you would file a lawsuit. Van Zandt Inc. files a lawsuit against Does 1 through 10, so Doe defendants. And
do you want me to put that up real quickly just so we can take a peek at it, Keith?
Sure.
Give me 1 second here.
And hence why the description says, you guys had to sit on this info for a couple days, kind of with a poker face. So just clarifying that little piece there.
Oh, okay.
Yeah.
All right. So here's the lawsuit, Keith. Let me do a call out here. You can see when it was filed. It was 9/27/2024. And I'll just pull that up so everybody can take a look at it. And it's Van Zandt Inc., the plaintiffs against Does 1 through 10 inclusive. We'll talk more about that in a minute, Keith, but this is the first time I've ever seen a complaint with just Does 1 through 10. We typically do include Does, but we have them with named defendants that we know and we can point to.
That's right.
And you can see that the plaintiff's address is 888 7th Ave, and somebody had posted the Secretary of State filing for California. This was a Delaware incorporated entity, but they had a foreign jurisdiction filing here in California.
Yeah.
And this was the address essentially for Blake Lively, or Blake Reynolds, I think is what the name was on the incorporation documents.
Yeah, and I know the California certificate that they showed that this company was no longer active in California. And, somebody was asking, I think, can an inactive corporation bring a lawsuit?
But it may just be inactive in California. It still could be active in Delaware and New York or wherever else.
Yeah, that's right. And I mean, technically, for a corporation to bring a lawsuit, it does have to be active in order to bring and prosecute a lawsuit. Obviously, I don't think that was the purpose here. I think what was going on is they filed this lawsuit, and then apparently they issued a subpoena. Now, here's the thing that I find frustrating. We have not seen the subpoena. And I would love to see this subpoena. It was apparently issued under the name of this lawsuit.
Josh Boswell did describe the subpoena to us in detail, but that wasn't good enough for us. We want to see it.
I want to see it. And Josh Boswell at the Daily Mail says that he saw the subpoena.
He had it in front of him when we were talking.
Yeah. And for whatever reason, they don't want to disclose that because we were told they don't want to disclose their sources, which, okay, fair enough. Reporters have a right to do that. But I would love to see this subpoena. But we have not seen that as of yet. We did ask, just was the subpoena, if you were looking at it, was it served on anybody else? And it appeared as though that was not the case.
And I think that's probably true, and we'll get into more of that.
Okay. So you have on September 27th, this complaint is filed. On October 1st, the subpoena is issued. That's what, 4 days later, 3 days later?
And I looked this up, Keith, and I'm not a New York lawyer, but under New York law, once an action's commenced, once a lawsuit's filed, you can immediately do discovery, sending out subpoenas. How is it in California?
Yeah, there's a 20-day discovery hold. So once you file a lawsuit, you have to wait at least 20 days before you can issue any discovery at all, including a subpoena.
And in New York, once you have filed the action, you can send out subpoenas.
Well, that's great. As a plaintiff, that's a wonderful thing.
Yes.
But that's what they did. After 4 days, they issued the subpoena. Apparently, they get the documents from Jones Work. I don't know. It seems as though they've only issued one subpoena. It happened to go to Stephanie Jones at Jones Work. And then on December 19th, and we have this document too, this Van Zandt lawsuit is withdrawn.
Let me pull that up
without prejudice. And if you recall, December 19th is the day before the CRD complaint is filed in California, which is December 20th.
So I've just called this out real quickly, and you can see here that they call it in New York the notice of voluntary discontinuance without prejudice. Again, we see Van Zandt Inc. Let me put my little laser pointer on here. We see Van Zandt Inc. against does 1 through 10 inclusive. That's just foreign to my eye. I'm not used to seeing only does listed. And then, of course, you see this Manat, Phelps, and Phillips, and it's Samantha J. Katz. I think I'm saying her name right, one of the attorneys there. And again, they say attorneys for plaintiff Van Zandt Inc., December 19, 2024.
Yeah. And can we go back to the complaint for just a second?
Sure.
And let's scroll down to the parties, which I think is on page 4.
Hey, while we're bringing that up, Amy Shepard wants to know, do you think this could have a backlash on the New York Times case?
So I'm betting anything that the New York Times asked about, did you get this information through a subpoena? They probably were told yes. Maybe they were even shown the subpoena. I think the New York Times has a right to rely on that. I don't think that they have to do any further investigation of that. And so I don't think it's going to affect them much.
I'm just guessing. And who was it that asked this question again? Amy.
This is Amy Shepard.
Amy, this is a really good question. I'm not sure what's going to happen here. I think the New York Times likely was duped a little bit here. And I think that behind the scenes, they're probably pretty ticked off about this. Just my guess, because I do think they do take their job seriously when these kind of stories come along, and they want to make sure that they're reporting, they're doing their due diligence to make sure they're not putting something out there that would be something that was not received from somebody that had a right to have it. Yeah,
it doesn't appear as though the Times was involved in any of this Van Zandt lawsuit stuff, whereas Manat, Phelps, and Phillips was the firm who filed it. If you look at paragraph 7, I just want to show the Doe defendant paragraph. So this is very typical of a lawsuit. So when we file lawsuits, we'll name known defendants, but we'll also say, and does 1 through 10 or 1 through 20, or sometimes you see does 1 through 100.
Just in case.
Just in case. There could be another party out there that has to come in as a defendant.
All 100 of them.
Very rarely. It's pretty rare that you actually add somebody in place of one of the does. And that's what you would do. If you find somebody who's liable, you would go to court and you'd ask the judge to substitute doe number 1 for, John Smith, and now they would be a defendant. But you can see here, upon information and belief, each of the doe defendants are individuals and or companies, and they just go on with kind of this language about how the does are liable through either themselves or their employees. This is all standard language. We see this even in California. We have the exact, maybe not the exact same, but it's very similar language to add a doe defendant. The difference here being there was nobody named. It was only does.
Just does. No other defendants named by actual name.
Right.
Right.
So we get to the point where the complaint is filed, the subpoena is issued. Now, what do we have in terms of the statements? So now you're showing the statement. Is this Ezra Hudson?
Yeah, I'm messing it up. Let me try this again. So here is a statement from Ezra Hudson, and it's 2 paragraphs.
So we obviously, everybody knows in our jury pool that we have praised Ezra Hudson's writing in the past, and for good reason. She's a good writer, and she's done good work in terms of her legal writing on the motions. Here is her statement, and I have to say I've got a problem with it.
Okay.
So she's saying that Doe lawsuits are common and entirely appropriate legal tools for pursuing legal claims and uncovering the identity of unknown perpetrators and unlawful activities. And then she goes on the second paragraph, to pretty much point the finger back at the Wayfarer parties and say, well, they're just upset because their little scheme was divulged and it wasn't supposed to be found. It's supposed to be untraceable. The problem I have with that first paragraph, so first of all, let's take this outside of the Lively versus Baldoni lawsuit. So just as a general proposition, can you file a lawsuit naming only Doe defendants?
You can. I mean, you theoretically can.
You don't normally, but you could.
Yes.
And could you serve a subpoena under a lawsuit that only names Doe defendants?
Theoretically, yes.
Okay. But what would be the problem with doing that in this situation when we're looking at it in the Lively versus Baldoni situation?
Because it's not fair. It's what others have called an abuse of the process. It's basically using good lawyering, or I don't know if it's good lawyering, but lawyers have sat around and thought about, hey, we always do sue Doe defendants. So when she says Doe defendants are common, that's true, but that they're usually common in lawsuits where there's named defendants as well.
Right.
And so I think it's very uncommon to see a lawsuit with just Doe defendants. And the purpose here is really what we're getting at. Why did they only sue Doe defendants? Because in New York, under the state statutes, the civil procedure statutes, you're only required to give notice of a subpoena to parties in a lawsuit. That's it. You don't have to give it to anybody that is the subject of a subpoena. And how would that be different in California?
In California, we have a law that requires what we call consumer's notice. And so when you're getting private information of somebody who's not a party, parties to a lawsuit get notice of subpoenas. Non-parties don't, unless you're trying to get their records. And so consumer's notice requires that we give notice of the subpoena before we even serve the subpoena. So you literally have to give a copy of the subpoena and the notice to the consumer. And then you have to tell that consumer, hey, I'm going to serve the subpoena in 20 days. You've got 20 days to object. And the consumer doesn't have to come in on a motion. They don't have to do anything complicated. All they have to do is fill out the bottom part of the notice. That says,
send a letter.
Yeah, or send a letter. But there's actually a part on the notice. I object.
Yes.
Send it on in to the attorney and whoever's the subject of the subpoena, and everything stops.
So here's the loophole, Keith. The loophole that these lawyers apparently found is we will just name Doe defendants, and we won't name any defendants we have to give notice to, in other words.
Yeah.
And then once we have this lawsuit on file, since we can immediately send out a subpoena 4 days later, we're going to send it to Stephanie Jones. How they knew to accurately send it to just one person, Stephanie Jones, that leads to a lot of questions. But they did give it to her. And then, of course, she just looks at the subpoena and goes, oh, I've been subpoenaed. I've got to give it to you. And nobody's the wiser.
Right.
The Baldoni doesn't know. The Wayfarer parties don't know. Anybody whose information was on this cell phone. Cell phones hold a lot of information.
Right.
These things hold so much information that's not relevant to a lawsuit. There's a lot of privacy issues. There could be medical records. There could be things that have nothing to do with this case that nobody has any business looking at. And this all comes back to the parties that have issued this subpoena, and nobody got notice.
Nobody got notice. And the problem I have with it is we know that Leslie Sloan had texted
Jennifer Abel
and Melissa Nathan saying, I've seen your text, prepared to be sued. So we know that there was some way, somehow, that Sloan and probably the Lively parties had seen some text. And why would you file a lawsuit to issue just one very specific subpoena if you didn't know that this person had some relevant information?
Because you knew.
Because you knew. You had to know. And so now you're thinking, well, I know who I have a problem with. On the Lively side, you're thinking, I have a problem with Baldoni, Wayfarer, Jamie Heath, but I'm not going to name any of them as parties because then I'd have to give them notice of the subpoena. So,
and what would happen if, and I'm sorry for interrupting you, but let's say that you did give notice to the Wayfarer parties and Justin Baldoni that you were seeking Stephanie Jones's phone, that was Jennifer Abel's phone. You were seeking all of this data that's on there. What's the first thing you would do if you were Brian Friedman or the lawyer that was representing the Wayfair parties?
You would bring a motion to quash the subpoena.
What does that mean?
You would bring a motion in court saying, I want the court to order that this subpoena cannot go forward, that these documents cannot be produced. This is too broad.
And when you file that motion to quash, and notice Stephanie Jones of that motion to quash, what does she do with that phone?
Immediate hold. Everybody has to just, time out. Hold. Don't produce anything. Everybody maintain the status quo until the court can figure this out. That's the beauty of filing a motion to quash, is that it puts an automatic hold on everything and everybody so that nothing more can happen there. And I think that that's ultimately the problem here, is that it really appears to be a lack of fair play on the part of the Manat attorneys in trying to get this information.
If this is what they did, if their goal was to secretly file this lawsuit, secretly only name Doe defendants so they don't have to name anybody else, so nobody else gets notice, secretly get this phone via a subpoena, I don't think that's fair play. I don't think that's what the rules of civil procedure or our conduct as attorneys in front of a court, I don't think it raises to the standard that it needs to. Now, the Manat lawyers are going to argue that they did everything by the book. They're going to say you're entitled to name Doe defendants. I don't know that there's any rule that says you can not just name Doe defendants, although I don't see, this is the first time I've seen that. I've been doing this 20 years. You've been doing this more than 21, 22 years. I've never seen this before. But they're going to say there was nothing in the statutes that say we can't name Doe defendants, because then we don't have to give notice to anybody because we don't know who we're suing. And by the way, once we file a lawsuit in New York, we can immediately issue a subpoena. Who are we to give notice? Because there's no parties in the case. So by the letter of the law, we abided by the letter of the law. But I think a judge will see it differently than that.
Yeah, that's interesting because, I think just by the letter of the law, you can say, but the problem is it's form over substance. And so you're trying to say we followed the correct form. But substantively speaking, when you take a look at the whole picture here, you knew what you were doing. And if all of this is true, you knew that you were trying to get something without giving anybody notice. That's the problem I have with it.
Keith, why didn't they just go ahead?
I don't want to forget about this question. We had talked about this. This was before the stream started. And we have a jury pool member that says, I want to ask Keith and Stewart, based on everything we have now in terms of the timeline evidence, if Baldoni loses, would you question their faith in the legal system as lawyers?
I don't think I would. I mean, I have tremendous faith in the legal system, obviously. And there's so many twists and turns that can happen between now and the end of this case when Baldoni wins or loses. And so you would have to take stock of everything that happens during that time frame. And ultimately, I think we put our faith in the jury system. And if the jury were to decide that Baldoni loses, then that's the system that we have, and we have to have faith in it. As of right now, based on everything we've seen, I'd find it hard to believe that Baldoni would lose, but there's a lot that can happen between now and trial. And so we have to wait and see, I think.
In many countries, and I'm not going to name any countries, but in many countries, Baldoni and his crew and Lively and her crew would have gotten sticks and knives and guns, and they would have started shooting at each other and, just killing each other. And that never ends. In our country, we have a justice system. It's not perfect. And many of us have seen where justice has not gone perfect, but it's the best system that I've ever been a part of and I've seen. And so I have faith in the jury system. I like juries a lot. I think judges, for the most part, are very good, and they try to do the best they can too. I just like juries because you got to get the jury. To get a judge, you're just getting one judge. But to get a jury to make a decision, you got to persuade everyone. And they're members of the community. And they use their common sense, and I pointed out that I think they're the smartest people in the room combined together. They usually get it right. So I do have faith that the jury will get this case right too, if it goes that far.
Yeah, and we've even seen that with our own jury pool and with these other content creators. I mean, I think that a lot of this is common sense, and I think we do add a legal flair to this discussion. But there's also a lot of people doing a lot of good work on this case, like Katie without a crystal ball, or I was listening to the Court of Random Opinion this morning. I mean, a lot of it is common sense. You look at this, and you're like, this just doesn't seem right, and she was making statements like that. And yeah, you're right. It doesn't.
Right. Before we got the question, I was going to ask you, why is it that Manat and Lively, and Team Lively, why didn't they just file their lawsuit December 31st in federal court like they did, And then why didn't they try to get the stuff from Stephanie Jones?
This is the thing that just puzzles the heck out of me, because let's just say that the Manat attorneys had seen all of the text messages from Stephanie Jones, but they're trying to figure out how can we use these. You can still make allegations in a complaint without being so specific as showing the actual text messages. You could say that we're alleging these things, and you could file your lawsuit based on those allegations. And then once you have the lawsuit filed, you serve the subpoena, give everybody notice. You know what's going to happen, though, is that you're going to get a motion to quash. But if I was sitting there representing Lively, I'd say, well, that's fine. Let them file a motion to quash. I think that we have an ability to get past that motion, and we're going to be able to get relevant text. They're not going to be able to keep them from us forever. So why not do it the proper way?
And if they had done it the proper way, I think I agree with you, Keith. I think they ultimately are going to get relevant texts and emails that go to their theory that there was this slime campaign that was going on. They'll be able to look at these things and put them in front of a jury and ask the jury, hey, do you agree with us on our position of the case? I'm just surprised they didn't do that. Now, I do want to say in September, there was a lot of things that weren't known that we know now today. So we have to be careful not to take the knowledge we have today and impute it back to decisions that were being made in September of 2024. But it seems like, you know, you and I were talking about this today at lunch. It seems like they kind of knew who they were going after here.
They knew at least one or two people. They knew Baldoni, Wayfarer, and Heath. I think that that's much they knew. Now, here's the one downside of doing it, you know, where you wait until you file the proper lawsuit and then you file your subpoena. You wouldn't be able to show copies of those texts in your CRD complaint, and you wouldn't be able to give copies of those texts to the New York Times. And so I think if you really want to have the public relations punch that they probably wanted, you have to have copies of those texts.
Do you think the lawyers at Manat thought that this would turn into what it has? I mean, obviously, everybody's focused on this case right now. And had they known that, would they have done this little end-around strategy of filing against Doe defendants to get a subpoena out directly to Stephanie Jones, who, again, they miraculously knew she had all this stuff, which you said that you think that there was information shared before the subpoena went out.
Yeah.
So they knew to go after her. Do you think they would still go forward with this plan?
I would think not. I mean, I think in hindsight, this is not looking good. It's not looking good in the court of public opinion. I don't think it'll play well in front of the judge, especially a federal judge. But think about their initial complaint where they talked about that dancing scene, and because they didn't think that there was audio and video of it.
Oopsies.
Yeah. And then they have to amend. And, you know, as the lawyer, all you can do is go off of what your client tells you.
Right.
So they do the first complaint, and then they see the video, and they're thinking, oh, shoot, we misstated that.
Right.
Because they were probably told the wrong thing. They were told things by their client, and you have to believe your client. You can't not,
right,
unless you know specifically about, you know, some lie. And so I think that there's a number of things that in hindsight, they probably would have, you know, walked a different path here.
Yeah. Yeah. I think you're right.
I'll sorry to interrupt. This is a kind of a segue along the same thoughts, but I want to shout this out from Anomaly G. They say, in your expert opinion, to go through these lengths, doesn't this suggest that what she claimed never happened, she being Blake? This seems really desperate for someone with the truth on their side. That's kind of what you were just saying, Keith.
Kind of. Yeah. I mean, I think this is a sign of somebody who, I think that they were trying to be clever. I think that they thought that they had a means to do something. And maybe they also thought that by disclosing these texts and doing the CRD complaint and reporting it to the New York Times, that that's as far as this was going to go. It may be that they didn't think it was going to go a whole lot farther, and they were kind of surprised by the response. But we don't, I mean, I don't know. That's just pure conjecture on my part. The problem, though, I had with Ezra Hudson's comments or statement is that she doesn't say anything specifically about this case. She says that Doe lawsuits are common and entirely appropriate legal tools. Okay, but what about this case? I think if you're going to come out and make a statement about what's happened here that looks like this, I think you have to at least go back and say something specific about this case. And I would think that if you're in their shoes, you would say something along the lines of, you know, back in September, we didn't have all the facts. We didn't know who was behind this. We weren't sure if it was Baldoni or Wayfarer or some other party. We just didn't know, and we didn't want to wrongfully accuse anyone. And therefore, we felt like we needed to do some discovery before we went any further. I think that would have been at least somewhat of a statement that would make I don't know that would justify what they did, but it's better than making a generalized statement that I don't think really hits the mark.
Yeah, no, I agree with that. I think that it's true that Doe lawsuits are used all the time, but they're usually used in conjunction with suing actual defendants.
Yeah. Let's look at what the attorney for Stephanie Jones has to say. So this was, again, from the Daily Mail article where Jones's attorneys claim that Jones did not leak, but rather complied with a legal court-ordered subpoena. And Mrs. Jones provided material to Miss Lively's team in response to the October subpoena. Why would Miss Jones fight a subpoena when she had nothing to hide? Well, let's think about that. Let's look at this agreement between Jonesworks and Wayfarer, and this was attached to the complaint that Wayfarer filed against Joneswork. And there was confidentiality requirements in this agreement. And you can see at the top here that throughout the client's engagement, they're already saying that there's going to be confidential, proprietary, or sensitive information about the client, its customers, or related parties. So there's all sorts of confidential information as they define it. And company meaning Jonesworks shall not use such information for any purpose beyond the performance of company services hereunder, unless otherwise required by law or a court of competent jurisdiction. So that's where they're getting at why they needed a subpoena. So in theory, they had a confidentiality agreement, but you could get around it by use of, as required by law or court of competent jurisdiction. But what happens when a company like Jonesworks gets a subpoena knowing that they have a confidentiality agreement between a client? Do they just bury their head in the sand and produce the information? Is that their only obligation? I mean, what is it that we have to do as lawyers? Let's say we have an attorney or a cell phone from a former client and we got a subpoena asking us to hand it over. What would we have to do?
Well, I can just use the Joneswork example here. When she received this subpoena, she should have forwarded it to the Wayfarer parties, all of them, anybody she could think of that information is on the cell phone. And she could have simply done a simple objection, which through the use of her lawyers, a simple objection that she was not going to disclose the subpoena because there are other people's privacy rights at stake here. And so she is going to object to it, which then would put the ball back in the court of Manat and Lively. And then they can go to that court where they filed that lawsuit against those Doe defendants, and they can try to convince that court that they should be able to enforce the subpoena and that Stephanie Jones has to turn this stuff over. But if they do that, now Baldoni and his team are on notice because Stephanie Jones gave it to them saying, hey, I'm under a confidentiality agreement with you guys. And yes, you're my former clients. And I understand there's some hard feelings here, but I'm being asked to turn this phone over. I don't want to do that. You guys need to do something about this. I'm objecting. I'm writing out a quick little objection, very easy objection saying I'm not going to produce this phone, not going to give it to him. And then Baldoni and his team could have come in to this court proceeding with these Doe defendants, and they could have appeared and they could have fought the transfer of this phone. But what really happened, Stephanie Jones, it appears, just says, oh, I've got a subpoena here, and she hands the phone over.
Well, and the statement that Stephanie Jones has nothing to hide misses the point. You may not have anything to hide, but you have a duty of confidentiality because of this confidentiality agreement. We as attorneys have duties of confidentiality. We cannot just hand over documents based on some subpoena that comes in. We have to take actions before we do that. And in fact, we'll even go so far as to not produce anything without a court order because you're just not going to risk it.
And that was the silver bullet for Stephanie Jones and Joneswork here. And that is, if she had written a letter and said, I'm not going to produce the phone, and then Manat and their lawyers went to the mat and said, okay, well, we're going to ask the court to force you to do it. And let's say the court does force her to turn over the phone. Let's say that somehow, some way the court comes to the conclusion the phone has to be turned over. She's not going to be sanctioned for that behavior.
No.
Because she says, hey, I don't know what to do here. I have to object to this because I'm under a confidentiality agreement. But if you get a court order that says I have to turn this over to you, I will. But let me ask you, if you were a judge in this court where these Doe defendants had been sued and Blake Lively is asking you to force Stephanie Jones to give a phone, and those are the only two people standing in front of you, what's the natural question you would ask?
Have you given notice to the other people who are affected by this subpoena? So who's affected by this subpoena? Well, Wayfarer, Justin Baldoni, Jamie Heath, Have they gotten notice of this subpoena and this motion?
And what if Blake Lively's team said, well, they're not parties to this case, Your Honor?
Yes, but they're parties to the information that you're trying to get. And again, this is where in California we have a specific law on this with consumers notice where you have to do it. But I think any judge sitting in any court throughout the nation would want to know, have the relevant parties gotten notice? Getting notice is such a fundamental concept in our legal system. And this is true in federal court, all of the state courts. Notice is everything. And in fact, in many cases, a judge doesn't even have jurisdiction to make a decision without proper notice. That's how fundamental it is.
And the whole point of notice is fair play. And really, we were talking again about this at lunch, and it's almost like the Lively and her team held a secret race that nobody else knew about.
Right.
And they won the race, right? They showed up, they ran the race, they had no competition to run it against them.
Right.
And that's not what we do here in litigation. There is you and I talked about contracts. People sue over contracts and the terms that are in contracts, right?
Yeah.
But inside every contract, in the four corners of every document, there's this implied covenant of good faith and fair dealing.
Yes.
And that doesn't have to be written down anywhere. It just means, hey, I got to be in good faith when I'm dealing with you on this contract, and you have to be in good faith with me no matter what the terms are, right?
Yes.
I think that applies to litigation. I think there has to be good faith and fair dealing when we're litigators. And I would like to ask the lawyers, what was the goal here? Was the goal because you truly didn't know who you were going to sue? Well, then why are you sending out subpoenas so specifically to somebody?
Right.
And why not just go ahead and notice them? If you had a right to this information, which you likely had a right to some of it that's relevant to your case, why didn't you just wait to actually give them notice and let them come up with their arguments? It's not fair that you did this. And I think that's what everyone's having a problem with here. It's just not fair. Although it does appear to not comply. It does appear under the rules, the civil rules in New York, that you can do this.
You followed the form of the law.
Yes.
But you missed the bigger point.
Yes.
There's a big point of fairness here that you missed out on.
That's right.
Yeah.
Well, here's one of the kind of questions of the day. Can Friedman use this to prove malice now? Everyone's wondering about malice. What do you guys think?
Yeah, so the malice has to do, well, I'm going to bring up 47.1, and I know that everyone loves when I bring up 47.1. The malice there has to do with the report of SH. And so did she report SH? Was she not reasonable in doing that? And was there actual malice in that reporting? And so you can have a lot of underhanded things that could happen that may not necessarily lead to a finding of actual malice under 47.1. Do you agree with me on that, Keith?
Yeah, the malice kind of has to predate what happened with the subpoena, I think. But the problem with everything that's happened now with the subpoena is you had made the point many times, Stuart, throughout our discussions on this, that your credibility in front of the court is very important.
It's everything.
And so now you've taken, I think, a big hit as to credibility in front of the judge. So there's problem number one. And then number two, you've taken a huge credibility hit just in the court of public opinion. I mean, you look like you're trying to do something underhanded, and that's not right.
By the way, you're the most powerful too. I mean, you know, Manat is this big, giant firm. Blake Lively, Ryan Reynolds, they're uber wealthy. They're famous. Play by the rules. Play by fair rules. You know, if there's nothing to hide here, then throw it out there for everybody to see. Don't do stuff behind the scenes when you don't have to.
But it's so tempting when you get really good information. It's so tempting. So let's go back a few years to a time when we handled an SH claim.
Okay.
All right. And you were the lead attorney on this case. And this was a case where you have two women and they were hard workers. They were kind of administrative assistant type level, not executives, no power in the company. And you've got the CEO of a company who, for whatever reason, takes a shine to these people and starts, very much coming into trying to kind of force his way into their lives, letters and statements and remarks and money, not little money either, like, big money. And you have, these poor women who are just there to do their job. They're supporting their families. They have no interest in this CEO guy. They don't want anything to do with this, but they also don't want to get fired. And so what are you supposed to do? The call comes into our office and we agree to take the case. You take the lead on it. And the defense attorneys come in for both the company and the CEO. oh, these guys played dirty.
They were pretty dirty.
Oh, the depositions about, what did our women, what did they wear, and talking about their sex lives.
Who did they sleep with at the district?
I mean, going really in depth about all the things that could make them look as though they're bad people, and also suggesting that they actually were into this and they were the ones who started it, which clearly was not the case. And then, you just kept pushing forward and pushing the case to trial, and you kept trying to get to that jury trial. And 3 times these insurance defense attorneys walk in and they give their lame excuses to why the trial has to be continued. And unfortunately, the judge is reasonable. They'll continue trials. Happens 1 time, 2 times, 3 times. You just cannot get this case to go to a jury trial until finally it does. And you're literally picking a jury. And for the first time, you get a settlement offer from the defense side. And it's big money because they know that they don't want to put this case in front of a jury. And ultimately, our clients, take that offer because it was just such a great, result for them and good for them. But something happened during that case where you and I were sitting in our offices. We had offices like right across from each other.
Which you loved.
Which I loved. Yeah. Right. Yeah. Yeah. Stuart.
Apparently I have a loud voice.
Yeah. Stuart can be a little loud when he's talking. He gets very excited. He's very passionate about what he does. And so we called it 2 offices and a door, and the door saved our partnership because we could shut the door.
Yeah.
But a package comes in. It's a pretty weighty package. It's a white envelope, and it hits your desk. You open the envelope, and I can see you when you're opening this envelope, and your jaw hits the ground. What was in that envelope?
Somebody from the company, an employee, had taken an independent investigation by a lawyer that the company hired after the SH claims were made. This is typically what companies will do. They'll hire in an independent lawyer. And it was this lawyer's report, and it was about 1 inch thick. And it described how all this SH took place, how it was inappropriate, and all the harm that was caused to our clients. And the only reason I know it said all of that is because we got the report much later in the lawsuit. But as I started to read the cover letter in this big stack of documents, I realized that somebody had sent me something that I was not supposed to be looking at.
And why was that? Why was it something you shouldn't be looking at?
Because I realized this was the independent lawyer who they had hired to come in and do a report on whether there was or was not SH in relation to this case. So I knew there would be attorney-client privilege claims there potentially. And I just knew that I immediately knew that somebody from the district, somebody that was on our side, somebody from the office had decided to send over this report.
So you suspected it was privileged under attorney-client privilege.
And other privileges as well.
But you also suspected that they had waived the privilege in some manner, right?
At some point later, we did, but I think at that point, I wasn't sure what to think. But the long story short, I stopped reading, and it was one of the hardest things I've ever had to do as a lawyer because this was really good information that could help our clients. And it was something that we could do to really benefit ourselves in that race against the other side. But because it wasn't fair, because the rules didn't allow it, I stopped reading, and I immediately came into your office because I needed some cold comfort to know that I was making the right decision. And I said to you, hey, I stopped reading this, but let me tell you what I think it is. And what did you say to me?
Yeah, we looked at each other. We looked at the envelope. We looked at each other. We looked at the envelope. And we said, we got to do the right thing. And that is, we have to contact the opposing attorneys and let them know that this happened. We have to destroy this or send it back to them, get it out of our possession. And we then, if we think that we can get it because the attorney-client privilege has been waived, we have to bring a motion to compel.
And it was one of the nicest phone calls I actually ever had with an insurance defense lawyer. He almost cried. I mean, he said, what is going on over there? And I said, look, I only read, I got through the first half of a paragraph and I realized what this was. What do you want me to do with it? And he said, could you please send it back to, could you send it to me? And I said, sure, I'll send it to you. I sent it to him. And, after that, he and I got along really well. We had not gotten along in the case at all, but we really did get along much better after that. But we learned later on through discovery that this report had been sent out to third parties. And once a report is sent outside to third parties, it waives any privileges.
Yeah.
And so then we had to compel in front of a judge, and the judge ultimately gave us this report. And then we did get to read it after all. And so we were able to see all the juicy details.
But what did the judge say to you when we went on that motion to compel to get this document, and the judge, read that we had received it, you stopped reading, you gave it back, but now you believe that the attorney-client privilege has been waived. You want the judge to order it to come over to us. What was the judge's response?
I mean, again, we're both tooting our own horn here a little bit, and I want to be somewhat humble about it, but it felt good to have the judge give me an attaboy. He said, Mr. Albertson, you did the right thing here, and I know how hard it was to do that as a lawyer, that where you could really benefit yourself. But the reason he was saying that, let's turn back to this case now, get away from us here. The reason he was saying that, the judge, because it's about fairness.
Yes.
It's about following the rules. It's about doing the right thing. And I wish all lawyers would think that way. Have everybody show up at the same time, fight it out as hard as you want within the rules, but just have everybody know what's going on in the case. There should be no Perry Mason moments. There should be no Doe defendant lawsuits being filed so that you get something without notifying the other side. I just don't feel right about that.
Well, and there's two things you did. Number one, you built a lot of credibility with the judge, which is always good in a case. And number two, now the evidence is usable in every way that you want to use it going forward.
Right.
And so there's no question that this is going to be used as evidence and good evidence. And it's probably, that's probably a big reason why the case did settle ultimately on the courthouse steps, because it was such good evidence that fell right into our hands. And, it's a great thing for our clients, but it's not something that happened by gamesmanship.
No gamesmanship. We ended up getting it fair and square. So, and that's really what this boils down to me. I would like to hear Manat's. They're a big firm. They're, obviously very bright lawyers, brighter than you and I. I'd like to know what was their reasoning. I'd like to know, did Blake Lively, did Ryan Reynolds know about this? Did they understand what they were doing? And then, of course, Brian Friedman is saying, I think I saw something where he says, hey, I had no idea this happened. So in other words, we knew nothing about this. And so it does cause some problems. I'll say one more thing. I think that the briefing here was going quite well for the Manat attorneys. And it's no surprise, as I have talked about Ezra Hudson and her wonderful drafting, which it is wonderful drafting. And it's not just wonderful from a writing standpoint. She's persuasive and she's doing a good job. But this now has given a new breath of air to the Friedman camp because of this behavior. And this is what happens in litigation. There's good days, there's bad days. And right now, I think I'm really interested to see, what does Judge Lyman do with this? It seems to me that there has to be some response from the court.
Yeah.
And then the question is, do you force the parties to disclose and disgorge all the evidence they have and start over in discovery? Are there evidentiary sanctions potentially? Are there monetary sanctions? Are there any? Does this rise to the level where a local bar needs to be reported to for the lawyers? I don't know the answers to any of those questions. Yeah. It just seems to me, though, that this was not right the way that it came out.
And does it put Ryan Reynolds and Blake Lively in a position where they have to fire their attorneys in order to at least try to save some face and salvage this situation?
After millions and millions of dollars.
Yeah. It could be. And we didn't show the statement by Brian Friedman because I think that we've kind of argued his point throughout a lot of this, but he did say that this appears to be an end around, skirting the process to be able to secretly get these documents without having to give anyone notice. That would be an abusive process, and we intend to take all action allowable under the law. Well,
good.
Hey, that's the thing, is that you've just handed Brian Friedman a gift, to be honest.
Yeah, because he has been, in my mind, he's been against the ropes a little bit with this 47.1 thing. Now the whole focus is on what the heck was going on here, this end around. And it's an abusive process, as he's pointing out. And he's saying, look, you guys aren't playing fair. And this lawsuit should be about fairness. Both sides should be able to put the facts and the witnesses and the documents forward as they see fit. But it should be done at a time where everyone knows that, hey, this is when we're doing it, and this is when the race starts.
Yeah, and what you're going to hear in every motion you see filed by Brian Friedman and his team is they've abused the process, gamesmanship, unfair. They're going to beat this drum for as long as they can, and rightly so.
Yeah, and again, Katie without a crystal ball, since we gave her a shout out at the beginning, we want to make sure anybody that has come on later, kudos to her, content creator. She's doing a great job. Thank you, Eric, for throwing that up.
Here's her channel. This is the video from yesterday. And she just put another video up about an hour ago, so we'll have to check that.
She's great. Well. If anybody wants, really in-depth view of the case, and she goes to the issue by issue, she's fantastic. So go over there. But again, I'm just proud of her because I don't know her, but I'm proud of her because didn't she text you, Eric?
Yeah, it was when we were on with Judge Liz yesterday. I got a text from her. She said, I found the lawsuit, for the subpoena. So
very cool.
Awesome. That was fine to see.
Yeah, good for her.
Yeah.
How about this one?
Work.
A couple people are kind of wondering about this. Lauren is asking, if the subpoena was not regarding a lawsuit for SH, is it protected under 47.1?
So the subpoena itself would not be protected under 47.1. The problem with 47.1 is the defamation claims that Baldoni has against Lively. And that's where 47.1 really rears its ugly head for Baldoni and makes it more difficult than if that law wasn't in place. As far as the subpoena, I don't think 47.1 is going to have an effect on that one way or the other, positive or negative. I think, there's other problems with the subpoena that we've described here.
I think it's just a matter of unfairness. And I think Brian Friedman's going to get every ounce of this argument out. And it really has flipped the script again in this case. So this case is flipping. This is, by the way, to the jury pool, this is what happens in litigation. Litigation is messy. It's never clean. When people tell you it's a slam, I love it when I interview clients for the first time. They go, oh, this is a slam dunk case.
Right.
And I have to tell them I've been doing this for 20 years and there are no such things as slam dunk cases. However, there are good facts and bad facts for both sides. And sometimes you have better facts than the other side. But these cases, they're hard. And here, because everyone's focused on it, there's going to be all kinds of 2 months from now, there'll be another shift in where we're headed here. There'll be another story that will come out. There's so much that can happen here.
I mean, this is war, and you don't win every battle in a war. You know, you can win you can lose a lot of battles and still win the war, and vice versa. So yeah, it's an interesting up and down.
This is one from Sky Knight, and there's a couple people. What would happen if the filing lawyers did the same thing in other lawsuits? And Tamisha Ford kind of says the same thing. Makes you wonder how many times Manat has gotten away with this. I don't know if that's fair to speculate, but what do you guys think?
That's just speculation. But Tamisha and whoever the other person was, what's her name?
Sky Knight.
Sky Knight. Beautiful name. I think you're right. This is a lawyer sitting around somewhere, or a team of lawyers sitting around somewhere saying, hey, you know how we do that Doe defendant thing? And you know how we have to give notice to all these people? What if we could figure out a way not to give notice to people and still get a subpoena? You have to think they've gone to this well before. We don't know that for certain. It's just speculation. And again, it meets the letter of the rules in New York. So Manat's lawyers are going to be able to say, hey, if there would have been parties in this case, we would have served them, Judge.
We didn't technically violate the law.
We didn't technically violate the law. And then a judge is going to say, yeah, but you got somebody's very private information. You knew who they were. Why didn't you name them in this lawsuit?
Yeah, it was only fair. And you know who you're going after. And I would not want to be in front of any judge, let alone a federal judge, with that argument and say, well, technically I was right.
Right. Yeah. Your Honor, let me walk you through the through the statute.
And the judge is like, no, I get it. I understand what you're saying. I mean, it's a technique that I've not seen before. It's not a technique we've ever used. And, it's interesting. But I think, obviously somebody thought they were being clever.
Alrighty, here. I thought this was funny. It says, Annie says, be more bombastic, gents. Don't denigrate yourselves. I'd never watch Manat's YouTube channel.
Thank you, Annie.
Okay, in more seriousness, John wants to know, a lot of people want to know, again, I mentioned this before, but does fairness or unfairness translate to malice, though?
It can. I mean, it certainly can. I mean, I think the problem with the whole malice idea is that the malice has to come out of the communications about SH. And all of those communications happened before this whole subpoena nonsense happened. And so it doesn't really help on the malice front, I don't think, but it helps on the overall lawsuit for Baldoni.
I don't think this is a jury issue, because I don't think the jury would ever be told about this one way or the other.
Yeah.
This is more of a judge issue.
And it's an exclusion of evidence issue.
That's what I'm getting to, is a judge can try to make this right. So judges can look when things that are not fair are done in cases, and they can do evidentiary sanctions. They can say, hey, you're not allowed to put this forward. Can't use it, even though it's something you could use normally in a case. They also have ways of making rulings in the case as it goes along, where they hammer the other side.
Right.
Sometimes judges do like the NBA referees, and they realize they made a bad call on one end, and then they make a bad call on the other end to make up for it. So, there's a lot that can happen here.
I mean, imagine if all of the text messages that we've seen between Melissa Nathan and Jennifer Abel are not allowed to be used as evidence.
Ouch.
Just gone.
Yeah. Yeah, no, that would be tough.
That's tough for Lively.
Yeah, it is. Yeah, and it may be fitting that the punishment may fit the crime.
Yeah, it might.
Yeah.
I want to shout this out from CJ. Kind of says what you guys mentioned between subpoena and then manipulating the text messages. I know that was right. So they manipulated the text messages and took away certain things, correct?
Yeah, and I think that Baldoni's Exhibit A pointed that out. Now, there was some argument that Lively's side had that it was the software we used that eliminated the emojis, which could happen. But I think the bigger issue is they didn't include all the text messages, and I think that Baldoni kind of corrected that with his Exhibit A, which is pretty damning.
Well, let me say, being unfair and not giving people notice of documents you want from them, and then later on trying to explain how you were being fair, it kind of falls hollow.
Does it gut your argument?
It got your argument just a little bit, yeah.
So CJ says, seems unethical on all levels, and thanks us for addressing the malice part. I thought this was interesting from Lydia Smith. She wants to know, do federal judges have more options for punishment for Manat compared to a lower circuit judge?
Only based on what Judge Liz said yesterday, and that is they have lifetime appointments, so they don't have to worry about being recalled or, somebody else running for their seat, or that they're going to be looked on poorly at some, judge's cocktail party or something. And also federal judges. Look, state judges I respect the heck out of state judges. But there's something really special about federal judges. I mean, you can actually feel it when you walk into the courtroom.
They don't mess around.
They don't mess around. And these people, I mean, they're some of the brightest people on the planet. It's a different experience in federal court than it is in state court. But state court judges also have a lot of power to address these very same abuses if they choose to do that.
Right. Yeah, that's true.
Here's from Tigesti. I've seen you in our chat before. So Lively has to amend her lawsuit then if there is evidentiary exclusion?
Not necessarily.
Nope.
Oh, we lost.
Looks like I lost my camera.
Lost Keith.
Darn connection.
So this is how the show should be anyway.
Yeah, that's right. Yeah. Everybody got a breath of fresh air.
So I want you to answer that, Keith, only because I don't know the answer to it. So let's see if we can get you back on. Otherwise, I can make up an answer. There we are. I think we're going to get to you. Keith, can you go back out and then come back? There you are. There he is.
Hey, everybody.
All right.
Remember me? What was the question again?
That's why it's a live show.
Amend the complaint.
Yeah.
No, she wouldn't necessarily have to amend her complaint. I mean, she did use a lot of those text messages in her complaint, but I think that she has sufficient allegations even without those text messages. Where it's going to come at issue is 2 points primarily. Number one is when it comes time for the party to do motions for summary judgment. Those are those Rule 56 motions that we've alluded to. That's another time when people might want to try to get a win before going to the jury. If you don't have those text messages, you don't have the evidence, it makes motion work a lot harder. And then the second big time when it's going to hurt is when you go in front of the jury. You're just not going to be able to present that evidence.
Yeah, that's true. Yep. One thing that hit me, I think Judge Liz may have pointed this out, and also Ron Zambrano. Wow, what a sharp guy he is.
Yeah.
He pointed out that you could file a motion to recuse Manat.
Yeah.
And that would be, I forget what he called it, flex move. That would be
the ultimate flex.
The ultimate flex, yeah. And man, I would bring that motion, even if I lost it, I'd bring it because oh my gosh, it would be so hard for Manat to get. I mean, they likely get through it. I don't know. Maybe I don't want to pine on it until we read the substantive facts. But that's Brian Friedman. That's just one of the things he should be doing right now.
Yeah.
The other thing he should be doing is asking for evidentiary sanctions. He should be asking for all evidence to be destroyed that are in the possession of Manat, and that they need to start over with true subpoenas, real subpoenas. I mean, there's all kinds of things he needs to be doing right now.
I'm sure there's a lot of things going on behind the scenes. I can imagine.
I say that humbly, Keith, because Brian Friedman knows what he's doing.
He knows what he's doing, but you're just suggesting the things. So,
okay, let's maybe we can end on this one. Peterson Nigel wants to know: doesn't this transfer the lawsuit to New York now? That starts in that court.
No. So you still have the choice of law. So even though it's in New York, every court, doesn't matter where it was venued, has a conflict of law section and rules. And so you're still going to have these arguments about which law applies. It doesn't matter if it's in New York court, federal court, or LA federal court, or wherever. So that really is not going to be a huge issue. I did see a question, Eric, about what does self-help mean?
Oh, yeah. Here we go. Can you explain what self-help means legally? That's from Sarah.
So Because we have heard this. I know Ron Zambrano used that term when he was on our show a couple days ago. So the typical issue of self-help, it would be like if somebody stole your car, what you're supposed to do is file a lawsuit for conversion and go through the legal process and get it back. What you're not supposed to do is trespass onto somebody else's property if you know that they have their car and your car in their garage and take it. And so when you undertake to do things outside of the legal process, we refer to that as self-help. And so I think what the point that was being alluded to with this self-help is somebody's going and just grabbing the documents for themselves outside of the legal process. And so that would be considered self-help versus using the legal process with all the proper notifications and everything, as we've talked about.
Effectively used for an SH suit with no right to sue. This might need a little more clarification. I apologize, but I don't know. Megan, we might need a little more.
Yeah, I'm not quite clear on the question there.
We want to get to it.
But I appreciate your donation.
Yeah. And maybe stuff like this dies down next week and we can cover some other things. But Carmen wants to know, can you guys cover the case of Abrego Garcia? You bringing up fairness and following the rules, and reminds me of what we were all wondering about Trump versus the judges right now. We've done a couple of videos on that.
We need to. I know the 4th District Court of Appeals just yesterday, it was one of the most beautiful written opinions I've read in years. And maybe we can get it and link it to this description. It won't make sense to link it here. Maybe we'll just talk about it next week. This obviously is going to be going to the Supreme Court, United States Supreme Court. But if you all want to read one of the best opinions, I think it's going to go down in history. I think this is going to be one of those things that your grandkids will be reading one day in elementary school, and they'll have a quote from this particular opinion. And it basically just says, we're better than this. We need to do better than this. And I was the judge who wrote it, too, is a conservative. He's been a conservative for many, many years, a very respected jurist. There was a 3-judge panel. So we'll talk about that next week. But that is a big issue going on in our country right now. And I feel for that man. I feel for his family and what they're going through.
Yeah, absolutely. Okay, I just want to follow up on what Megan. She didn't obtain a right to sue letter. Shouldn't she need a right to sue notice to ask for discovery intended to be used in a SH lawsuit?
Well, she definitely needs a right to sue letter to sue under California law. And there is a similar concept under federal law, but Lively brought California claims, something like 6 or 7 California claims. And so my understanding is she did get a right to sue letter there. I don't know if she did or did not under the federal statutes, but be that as it may, the fact that she did get one supposedly under California is enough for her to bring those lawsuits.
I don't know if this was in relation to the Doe.
The Doe
filing,
yeah.
And in that case, it was a breach of contract claim, so it didn't have SH in it. So
that's what it said.
Yeah, it also ironically had breach of covenant of good faith and fair dealing, which just ironic because that's the point we were making, that you probably have that same duty as lawyers when you're fighting a case.
Yeah, that's right. Yeah, breach of contract, breach of covenant, and faithless servant liability.
Okay, I keep saying one more, but we can wrap on this kind of.
Wait, I think do I see the tilted lawyer also through something? Is there a comment or a question? Anyway, go ahead.
Oh, okay. Hang on.
Let's go. Sabra.
Sabra is just saying, with this major revelation further confirming Baldoni's timeline and strengthening the overall picture, you can bet Brian Friedman's circling the possibility of a second amended complaint with a grin.
Yeah. And by the way, his letter, I loved his letter on April 15th to the court, where he says, we stand on our first amended complaint.
Yeah.
And he goes, but if the court goes against us,
we'll amend.
Yeah.
Which is, I mean, we do that all the time.
That's typical. Yeah.
Yeah. There's a lot of cases where we'll have demurs and we'll say, well, let's see what the judge has to say about it. Today was their deadline for all parties to amend or bring a motion to amend.
We liked the idea, Keith, that they didn't amend. We liked Brian Friedman's take on that because if the court finds against them, the court's going to outline the deficiencies that he sees,
right?
And it's going to give them a roadmap for fixing those deficiencies in a second amendment complaint.
Yeah, because the court will say you didn't say this. It's like, oh, okay, we'll say that.
So you do file, save as, and you say what the court said, and you refile the complaint.
And that's why you let it go to the judge sometimes. Yeah, it makes sense.
Okay, all right. Fellow content creator, our Rolodex is growing by the day. This is Omar, the Tilted Lawyer. What about the floating theory that SH was a prophylactic move to discourage Baldoni's coming conspiracy claim. They knew Friedman was around since August.
So it was a prophylactic move to discourage Baldoni's coming conspiracy claims. Yeah, that's interesting. So, I mean, it could be that they were just trying to beat him to the punch or beat Baldoni to the punch. I think it's kind of interesting. If you put yourself back in September of 2024, did Lively know at that time that she definitely was going to file a lawsuit?
I don't know.
Yeah, I mean, we don't know. And it could be that that's part of the reason why they decided to do this doe technique, although it seems like they knew if they did file a lawsuit, who they'd be filing against. But and I also wonder, how far did she think this was going to go? So did she think that she was going to file the CRD complaint, report it to the Times, and that would be the end of it? Baldoni would be buried and go away? You know, I don't know what happened there.
And I would say that I don't think any of the parties knew that this case would take on the life that it has.
Yeah, well, that's probably
and
true.
the scrutiny that's come with that.
Yeah,
yeah,
that's for sure.
Yeah.
Well, great. I think we can wrap on that. I just want to shout out, I look at our analytics and our views are from about 40% of people subscribe, but 60% of people don't subscribe. So please consider subscribing. We try to have a couple, 2 or 3 videos every week. We got new guests. We might have some pretty cool journalists and other content creators coming on next week. And yeah, please consider subscribing and rating the show on Apple Podcasts, Spotify, things like that. I'll say it because Keith and Stuart won't.
That's right. Well, thank you everybody to the jury pool and tuning in today, tuning in the last 2 days.
Outstanding questions.
Very good questions.
Yeah, there's 4,500 people in here too. So,
oh, wow.
So apologies if we didn't get to every single question. I did my best.
Yeah, we do as much as we can. We wanted to come back to you. We have some more content coming next week. We were hoping to come back on Monday, but our pesky day jobs have us in a mediation all day on Monday. So we probably won't be able to tune in until Tuesday. Shout out again to Without a Crystal Ball for her good work. We really enjoyed learning about all of this from her, and obviously from the Daily Mail article that came out today as well. But we really do watch other content creators and enjoy the work that they're doing. And we do read our comments, the good and the bad. And overall, we really appreciate all the support and all the good statements and questions. It's been fantastic.
We'll see you all next week. Everyone have a great and safe weekend. We don't just talk about the law, we practice it. At Albertson & Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.